All right, still with me, criminal defense attorney Kirk Nurmi and former judge Brian Eiton. This type of case just really makes me angry that we have these type of individuals who would put a child in a box, basically living in an 8x8 box. I want to first just get your overall reaction to the charges and to this motion filed by the defense. I'll start with you, Kirk. Is there any ground to this?
Yeah, you're right. Their conduct, if true, as alleged anyway, is simply vile, Ashley. So certainly, excuse me, Chanley, you certainly don't want them to prevail in that situation. There's certainly maybe some merit to it. They cite some Florida law regarding the illegal attainment of this stuff. But I wonder too. I'm interested to see the state's response because it doesn't necessarily lead to suppression of this evidence. And I'm also wondering if this evidence, these actions couldn't otherwise be legally justified as a defense of a child. So there's a lot more to it. This looks like playing out like a law school exam question, quite frankly, with all the issues, even attorney-client privilege. Yeah. So there's a lot here, but ultimately I don't think they're going to prevail because the kids were acting to protect their, I guess, adopted stepbrother.
And what might be in these emails, it's interesting, a lot unanswered still, like you said, Kirk, for this case. And this sort of, Judge, reminds me of the Turpin case, the parents who chained their kids to the beds and they couldn't leave the house. I mean, this is just unconscionable here. We know a lot of this information, the court file is sealed, under seal, so we don't know a lot of the details here, but the charges in this case, aggravated child abuse and false imprisonment. Is there anything else maybe that, we don't know a lot, but that this prosecution could do in this case?
Well, certainly aggravated child abuse carries substantial penalties, as does false imprisonment. Ultimately, it sounds to me as if, again, if proven is true, you have a clear violation for which there would be no justification. I mean, reasonable minds can differ about the use of parental discipline, the proverbial spanking or even corporal punishment, but caging in this fashion is unimaginable. And I agree with counsel that the thought of there being evidence subject to suppression, I mean, typically when we think of suppression, we're talking about unreasonable searches and seizures performed by the government. Well, the children in the household weren't agents of the government, and how their actions could somehow leave evidence unavailable for use of the prosecution without knowing more, I simply don't buy that theory.
Interesting. Any last takeaways real quick, Kurt? I'll give you the last word.
Yeah, this is just a horrific case. I think ultimately this evidence is going to come in. You're right. There's so much that has been sealed behind it, but I think ultimately there's no reason this evidence won't come forward and can be used as prosecution. And the judge is right. You think about the number of counts of false imprisonment and child abuse that are available. I think it should be enough to put these parents away for life.
Right, and hopefully these kids are in a better home and environment as they continue to grow up. Thank you both for your insights on that tragic case. But coming up, we're going to talk about the testimony phase.